In this session we are going to see about the Arbitration and Conciliation Act. Arbitration is one of the alternate dispute resolution mechanisms. There are four main mechanisms as alternate dispute resolution for alternate dispute resolution. One is negotiation, second mediation, third conciliation, and fourth arbitration. That is, in case of dispute, a person has to approach the court. The court will give a judgment. Both the parties have to abide by the terms of judgment. If they want, they can go for appeal, and there also another judgment is given. They have to abide by all the terms and conditions given in the judgment. But it will take some time. Money is involved. So, the alternate dispute resolution mechanism has come. There are four things, main things. There are many. Among them, four are main things. One is negotiation, next mediation, third conciliation, fourth is arbitration. Negotiation means two disputing parties sit together and they arrive at a settlement. They arrive at a solution for their problem. For example, there may be two political parties. At the time of election, there may be a dispute over sharing of seats. One person may demand 50, another person will be willing to give only 30. They sit together, they talk to each other 1 day or 2 days or 3 days. At last they arrive at a solution. Because it is only a dispute among them, they only can resolve it. This is called a negotiation. Next is mediation. Under mediation, another third party is involved. His job is to bring both the parties together. He has no role to play in settlement, but his duty is to bring them together. For example, there may be a chartered accountant or advocate or a bank manager. In their family, in their known family, another two brothers may be disputing over the property on participation. There may be joint property, some factories, lands. There may be dispute over that sharing of the property. Since this is a brothers, they may not be in talking terms. What the bank manager or the auditor will say, you come to my house over a cup of tea, we will talk. And he will invite both the parties. He will be sitting with them. He will be asking them to talk to each other over the dispute and arrive at a solution. This mediator is for making them to sit together. Another example, there may be a husband and wife applying for divorce. What the court will do? Court will refer them to the mediation center. At the mediation center, husband and wife will be asked to come. This mediator will talk to them. He will help them to arrive at a solution for their problem, to settle their issues. This is mediation. Next is conciliation. Under conciliation, the conciliation person has some more role to play. For example, there may be a dispute between the employer and the employees union. Employees union may demand 20% wage increase. Employer may be willing to give only 5% increase. Then the conciliation officer appointed by the government, he will ask both the persons to be in his office for a talk. He will be suggesting something, some solutions. Why can't you accept this 5% this year and the employer will give another 10% in the next year. Current year there is no profit. All these things he can suggest and make them to agree on the proposal. They themselves can agree on their proposal, or conciliation officer may also suggest them to arrive at a solution for their problem. This is conciliation. Next is arbitration. Under arbitration, they find out a person to say this is correct or this is not correct. These two persons have a problem. Then what they will do, these two persons is going to a third person. say, sir, this is our problem. You say who is correct, what we can do. So problem is given, he acts as a judge like a court and he give his verdict, that is called award, arbitration award. This is more convenient for business people. This Arbitration and Conciliation Act was passed in 1996. Only conciliation and arbitration are given legally. These regnants, the negotiation and the mediation are not coming in the Arbitration Conciliation Act. Only these two types of ADR, that is alternate dispute resolutions, are coming into the Act, Arbitration and Conciliation Act. Now we will see what are the advantages of having arbitration over the regular litigation, over filing of suit. One is privacy. Under arbitration, these people, they are two persons, a dispute, persons with the dispute go to a third person. They decide their own role. They decide their own place. That is why there are so many advantages. We will see one by one. One is privacy. It is conducted at a place, their own place. They will decide where to conduct. For example, a person may say, in our factory there is one office room. You take this room and we will conduct the proceedings there. So it is privacy. If it is the case with the court, everybody will be watching, hearing what these people are saying. Most probably the next day the newspaper item may also come, news item may also come in the next day newspaper. There was a dispute between these two people, court proceedings was like, will be reported in the news also, paper also. For example, Delhi company supplied a machine to company in Chennai, 10 crore rupees. There was a purchase order, but the machine is not giving the output as promised, or the machine is taking more power than promised. Some type of disputes. If it is a dispute, they can decide with an arbitrator. But if the same case is going to the court, in the court they will discuss all these things in the open court. The next day newspaper item will come. This company is having a dispute over the other company. This company's machine is like that. It will have all negative impact on the business. So privacy is the main thing. That is why business people prefer arbitration. Their business connection is not affected because of this. Once you go to the court, that relationship will be affected. Privacy is there in arbitration. Next, experts. They can appoint the experts. For example, the same example, a machine with the 10 crores, output is not there, power is taking, more power it is consuming. In such a case, instead of going to the court, they may appoint a well-qualified person as arbitrator, an engineer, or some other person connected with the manufacturing activities. He will decide what is correct, what is not correct. He will give his award. They can have an experts of their choice. Third is venue, that is place, where to conduct all these things. They themselves can decide. That will be convenient for them. If it is a court proceedings, they have to go to the court every time. They have to stay there from the morning till their case is taken. Next is flexible rule. For arbitration, this civil procedure code is not applicable. They can have their own rules. They can say that no oral hearing, only written submission. You give your report, I will, your claim report you give, I will give a written response to that claim report, and based on that let him decide. Like that also they can decide. They decide their own rules. Next is cost is low. It's a low cost because in the court proceeding you cannot say how long time it will take. You have to go to the court, go to the advocate office on the previous day to inquire about all these things. So cost wise it is less. Next is faster. Arbitration, this proceeding should be completed within 12 months, and at the most it can be extended for another 6 months. It is not the case with the court proceedings. It may take longer period. Next is simple and informal. In the court, everything is formal. You have to go, this statement, this petition, this affidavit, all these things, so many technical things you may not be knowing. But here everything is formal. Just like that, you go sit and talk to the arbitrator. Arbitrator will talk to the other person. They finish the things. It is so simple and informal. Next is award is final. Even if you go to the court, one judgment for against that, you can go for the next appeal. But here, once the award is given, it is final. Only 3-4 limited instances you can go for a appeal to the court. Otherwise, the award is final. Next is no stress. Because it is your own proceedings, it is informal, there is no stress, no confidentiality, no emotion burden. Cordial relationship is maintained. Since you have decided, we will decide the case according to the other person's award. There is nothing that business people will continue with the cordial relationship. Now next comes how to make an award arbitration agreement. In two ways you can make an arbitration agreement. That is, one, at the time of doing the contract itself, you can make a clause in the original contract. For example, the same example will take. That is 10 crore machine purchased from Delhi to Chennai. At the purchase order itself, they will make a condition. Purchase contract, they will make a condition. In case of any dispute, this will be referred to this person who will act as an arbitrator. Or in case of dispute, we will refer the matter to the arbitrator at our choice. So, it forms one of the clause of the original contract. One. Second, if after the dispute has arisen, for example, you think same thing, 10 crore machine purchase, no arbitration clause in the purchase agreement, dispute has come about the output and the power consumption, then both the parties will decide, anyway dispute has come, we need not go to the court. You claim something as compensation, I will also claim, I will also pay, but how much compensation to be paid, that let the arbitrator decide. They can decide. Now they will make another agreement. We have executed this purchase contract and a dispute has arisen about the output and the power consumption. This matter may be placed, we agree that this matter may be placed before the arbitrator. Now this is a separate agreement. There are two ways of doing things. That is, one is at the time of writing the agreement itself. In case if there is any dispute about this purchase, this will be referred to the arbitrator only. This is one. Second is, you can have an agreement to refer to arbitrator after the dispute has come. These are two ways. What section 7 says, that agreement shall be in writing, no oral. The agreement shall be in writing. Section 7 subsection 3 says, agreement shall be in writing. Agreement may be in a separate contract or agreement may be in one contract. In that case, if the agreement is in one contract as a clause inside a contract, it should be treated as a separate agreement. Even if the original agreement is void, then also the arbitration clause will be valid. For example, same thing, that purchase agreement, subsequently they found out the agreement is void because the agreement was signed by a person who has no authority to sign. Even in that case also, even in the case of void agreement also, the arbitration clause will be valid. This is, they say, as separability. That is, arbitration clause is separate from the original contract. Arbitration agreement shall be valid. There is no formality writing agreements. Let it be, it can be of any type. That is why section 7 clause 4 says, it shall be the document signed by the parties. Or even it may be an exchange of letters, telex, telegrams or other means. For example, dispute has come about the machine. When this person from Chennai is writing a letter to the other person in Delhi, this is a dispute, we wish to give it to the arbitrator, or you agree? The other person, yes, I am agreeing, we will refer the matter to the arbitrator. Now this is an agreement. So agreement may be in writing, agreement should be in writing, it may be a separate agreement or one clause in a original agreement. This may be by way of exchange of letters also, telex or telegram, all these things, or even exchange of statement also they make it, then also it can be a arbitration. Then what constitute an arbitration agreement? Now what the section says is there is no formality, no format for the agreement. Then how to arrive at that, whether this is an agreement or not? The presence of the word arbitration does not mean that it is an arbitration agreement. What you should see, the intention of the parties. The intention of the parties while executing the document should be to refer it to agreement, refer it to arbitration. There is no specific form. The word arbitration does not mean they have to be, there is an arbitration agreement. In tender forms, if the original tender issue of tender forms contain an arbitration agreement, then there must it should be construed that there is an arbitration agreement. In one case, Banwarilal Kotia versus BC Agarwal, it is regarding share transfers, sale deal, share transfer deals. It is a business about purchase and sale of shares of stock exchange. Their sale agreement contains a clause, this is subject to the rules and regulations of the stock exchange. Rules and regulations of stock exchange as a condition for arbitration. It was held that since your agreement mentions that this is subject to rules and regulations of the stock exchange, and since the stock exchange is having a clause for arbitration, your agreement is also subject to arbitration. Then another case, MR Engineers and Contractors versus Sam Dutt Builders. The original main contractor had a agreement which has a arbitration clause. He entered into with a subcontract to another person, which is making a reference to the main contract. That is, main contract has a arbitration clause. He was making a subcontract with some other person. There also he mentions about the main contract. In that case, court held, you cannot say that since a main contract is having arbitration, subcontract is also having the same thing, because parties are different, the matters are different. So, main contract as arbitration clause does not mean subcontract should also have a arbitration clause. Then separability, already we have seen that contract is separate from the arbitration clause. Whether the contract is valid or not, but the contract, this arbitration clause will be valid. In the next session, we will see about the appointment of arbitrators under arbitration clause.